Thank you all for coming out today for this conversation on civil asset forfeiture. It's sure to be productive. Just one item of business I'd like to note is that this Friday, the 12th of December, we are actually having another, two panels actually, in Harris County at the Harris County Justice Summit. Details and information registration are available online. That monthly visit is free of charge. I would like to see anybody that can make it out there, learn what we can do to apply some of the principles that we discuss in our Center for Effective Justice, also in Harris County as well. So, without further ado, civil asset forfeiture, an unfair exercise in forum shopping, a sustained assault on Fifth Amendment due process, policing for profit. Conversely, picking up the torch dropped by budget authorities interested in playing politics, an indispensable tool for combating increasingly sophisticated criminals. These terms have been used in the academic and popular press about civil asset forfeiture, the very phenomenon that we're here to discuss today. My name is Derek Cohen, and I'm the policy analyst for the Center for Effective Justice at the Texas Public Policy Foundation and in our Right on Crime campaign national. I'll be your moderator today. Just one quick item of housekeeping. If you'll notice on the original invite, Chief James McLaughlin from the Texas Police Chiefs Association was originally scheduled to join us today. Unfortunately, he had a personal incident come up, and pinch hitting for him is Shannon Edmonds. Shannon was asked, basically as late as possible, if he could sit on his panel, and he gratefully obliged. So to that, we're thankful, Shannon. Thank you. Forfeiture proceedings are simple enough to understand in the abstract. An individual commits a crime. During the commission of this crime, they either use or come into the possession of an item of property, either real or intangible. The crime is discovered, and amongst other punishments, they are deprived of that property. The state gains possession, and they are able to dispose of it in the manner best suited to the agencies that actually made that seizure. Now, as with most instances in legal procedure where the rubber hits the road, it is rarely that simple. Would-be defendants may flee, leaving property unattended and having to be dealt with regardless. Remediable errors in criminal procedure may happen, and that might actually cost the state its jurisdiction over a criminal enterprise. Police and prosecutors are then left with property, maybe even contraband, and have to dispose of it regardless. So, in such cases, the property itself is what becomes the target of the procedural action, not the human perpetrator. These proceedings are colloquially deemed civil asset forfeiture, the state taking ownership of the property without an attending criminal conviction. It is the legal provisions that empower this that are, to some critics, what create the perverse incentive structure that some have deemed policing for profit, one in which prosecutorial and police discretionary decisions are made more in line with what might materially come about than with the true instances of justice. But again, with that, would that it were that simple. The first instances of property forfeiture, if we look back through the history of law, is when property was forfeited back in Roman law under the concept of noxal surrender. The concept of noxal surrender simply is where an item of an individual's property has harmed the property of another. This was, sadly to say, mostly to deal with offenses committed by slaves. And then that property and perhaps other property was actually used as remuneration. This evolved in the 11th century to the English law concept of deodans. Deodans are, simply put, an instrument that is ostensibly forfeited unto God, though in practice forfeited to the king, because of its intrinsic evil, its intrinsic complicity in an evil act. To wit, people don't kill people, demonic swords kill people, and then the king actually gets the forfeit. Contrast this with attainder forfeitures, which were the historical analogs of criminal forfeiture, where a felon's property, both real and personal, was divvied up between their direct lord and their king as punishment for his crimes and remuneration to the violation of the king's peace. This unilateral seizure of property became less prevalent in the wake of the Enlightenment and the social, cultural, and legal changes that brought about. Robust protections emerged in common law that were also codified in the statute. Like most provisions found in the Bill of Rights, here the Fifth Amendment actually was a direct response to the abuses of due process and takings that came from the Crown. Protection aside, the framers of the Constitution did not think it appropriate to actually forbid forfeiture entirely, and perhaps rightfully so. In a fledgling nation, both deep in debt internally and externally, the only way to keep the government afloat was to tax a small diffuse tax base, or to supplement that with fees, tariffs, and property seizures from smugglers hoping to avoid these duties. Now, the wholesale adoption of in rem, that is, against property forfeitures, were pivotal in keeping the Republic afloat, and they aggrieved, at worst, foreign nationals seeking to circumvent U.S. law. Now let's fast forward today. Forfeiture, on behalf of the government, is practically ubiquitous at every level. Nationally, the use of equitable sharing agreements to split up forfeited property has increased at a rate outpacing inflation since it was codified, despite the long-standing drop in crime rates. In fiscal year 2012 alone, regional and local law enforcement entities in Texas reported closing the year with over $143 million in their forfeiture accounts. This is not part of any sort of budgeting process. To be clear, this number also includes forfeitures made pursuant to criminal forfeitures. Forfeitures made pursuant to a criminal conviction. However, to actually tell the difference between the two under current law is nearly impossible. To paraphrase Don Willett, Justice of the Texas Supreme Court, in his biting dissent in LLE versus Texas, this was the adjunct case to State of Texas versus 2004 Chevy Silverado. To paraphrase, the prevalence, procedures, and profitability compel us to re-examine the constitutional protections due to innocent property owners. This practice is what we actually chronicle in our report, Taking Contraband Without Taking Our Liberties, Civil Asset Forfeiture Reform in Texas. This is available online at texaspolicy.com, or it's also available in the back of the room if you'd like to take one before you leave. So to discuss this tricky topic, we've assembled a panel of top echelon stakeholders, from law enforcement to legal theorists, and even a state representative, to discuss the lay of the land and to discuss what reforms that we have coming in the 84th legislature. Our first speaker is Andrew Kloster from the Heritage Foundation, legal fellow in the Edwin Meese III Center for Legal and Judicial Studies. He focuses on civil rights, the role of the federal courts, and other constitutional issues. Before joining Heritage in 2013, Kloster was the Justice Robert H. Jackson Legal Fellow at the Philadelphia Foundation for Individual Rights and Education, or FIRE as we know. There he defended First Amendment due process rights of college students and professors. He has also worked on Capitol Hill and with a human rights organization under the United Nations. Andrew?
Thanks a lot, Derek. First of all, I'd just like to say thank you to TPPF. Heritage works with them on a number of criminal justice issues, and they do really innovative work, not just in Texas, but across the border of the United States. So I really appreciate the work that you guys do. And also thanks to IJ. They're constantly litigating these issues and working really hard to defend individual property owners. So I'd just like to start with that. Also, I would like to point out you have one of the papers that we put out at Heritage, just came out a few days ago, on civil asset forfeiture reform in DC, and some examples. You'll probably hear a lot of this from Matt. What are different types of reform that you can do, ranging from the extremely limited to the more robust reforms and kind of the benefits and harms that those reforms may have. So, okay, civil asset forfeiture. On a panel on civil asset forfeiture, it's a little bit tough to be the first panelist because, the name alone is just ridiculous. In government, you name, oftentimes lawmakers will intentionally or unintentionally give things a name that is sort of so bureaucratic and opaque that nobody's interested in it, but this is just a hugely important issue, so let me give you some examples. The core example of forfeiture, of what it was designed to seize, was contraband. contraband, drug paraphernalia, or a giant wad of cash that was sitting on top of a bag of drugs that the police happen upon. Nobody's going to claim the property, so it's not going to be a criminal, there's not going to be a criminal prosecution, but the property's still out there and they wanted to seize it. Or maybe you have a house that was purchased with drug money, or a house where drug deals take place on a routine basis. And all of this makes some sense, although folks may disagree with that. But it was these core cases that were the impetus behind forfeiture being ramped up really in the 1980s. And these are the cases that my former boss at Nice talks about as, when he was the 75th Attorney General of the US, he says, gosh, this is why we were told that we needed to improve civil asset forfeiture. Okay, but nowadays we have numerous examples of police using civil asset forfeiture not to go after these types of issues or cases, but as a revenue raiser. And I'm sure that Matt Miller from IJ can give some horror stories of clients that he's had or his organization has had. But I'll simply point you to 3 resources that you can take a look at if you want a really popular 30,000-foot view of these issues. The first is the New Yorker article, which I think was a watershed. The New Yorker article taken by Sarah Stillman, and that came out in August of last year. And she gave the example of a case, an ACLU case in Tenaha, Texas, 8 miles from the Louisiana border, where local police pulled over the Henderson family, for example, for driving in the left lane without passing for some period of time. Now, there are factual disputes about whether that was the case, but they pulled him over and said, you're driving in the passing lane, do you have any cash? And they took $6,000 in cash from this family, and then threatened to call the equivalent of DCFS and take the couple's children who were driving with them unless they willingly signed over the cash. So this was in the New Yorker article. This is a case that you can find, and there was an ACLU case against it. The second resource I'll point you to is the Washington Post series of articles that began earlier this year, which highlight numerous stories such as that of the IJ client Terry Dacko in Michigan, and his small business. He was a grocer. He was an immigrant. He had a small business, and basically his insurance said, we're not going to cover any cash losses over $10,000. Okay, that's reasonable, that's insurance. So what does he do? Like any normal person with an insurance policy, he says, if I ever get $9,999 of cash, I'm going to deposit it to the bank because I don't want to have any more on hand, because then I will not be able to have my insurance cover those losses. So he does this time and time again. Next thing you know, the IRS has seized $35,000 in his operating account, saying, gosh, it looks like you're trying to evade our reporting requirements, because the IRS has a rule, which is if you make a $10,000 cash deposit, that needs to be reported to the IRS. And if you do it in such a way that it looks like you're evading these requirements, that's something called structuring, that's a federal offense, and they seize the cash. So you ended up getting the money back thanks to pro bono representation, but I mean, when you have all of your money seized, you really can't hire a lawyer, and that's a huge problem. So the first to take a look at is the New Yorker article taken. The second is the Washington Post series of articles. And the third that I would point you out to is the third thing is the John Oliver segment, which you may have seen. He has a show last week tonight. It's a kind of comedic, sort of Daily Show-esque sort of show, but he's been doing very good work. And he recently, and you can find it on YouTube, he recently did a video on civil asset forfeiture and involving Texas and some sort of forthright legislators and Margarita machine. Okay, so those are some of the examples of abuse, and I'll leave it to Matt perhaps to highlight some of the more, take a more structured account, maybe some of the problems. There are due process problems, property rights issues, and federalism issues, because oftentimes the feds say, hey, you've got state laws against use of funds in a certain way, but we're going to give you cash directly using federal law, and we can avoid state law issues. So your state legislators, you have the power of the purse over your local law enforcement, but the feds in this area are often coming in to try to do an end run around state reform. So why has not reform occurred? If it's so easy, why are we even having a panel on this subject in 2014? Well, I would point out that sometimes there are law enforcement lobbies, for lack of a better word, and I work at a conservative organization that is very sensitive and very concerned with law and order issues. But I think the major lobby against this right now is the law enforcement community. That's not to criticize them. I think they may not understand some of the incentives here, and it may be in their benefit to actually have reform. So that's what I'm going to talk about. Let me skip since I don't have too incredibly much time. So why is this potentially a good thing for law enforcement to have forfeiture reform? First, I would just explain that ordinary budget appropriations is the carrot. If you're a state legislator, one of the things you can say is, if we're going to have forfeiture reform, you, local law enforcement, come in and tell me how much money you're going to have as a shortfall. And we can consider, if we turn this forfeiture, the forfeiture funds go back to the general fund, and then we can have a conversation about how much money you actually need, for example. This is the conversation that occurred in DC, where forfeiture reform was passed recently. And that's potentially a tough hurdle, but I think ordinary budget funding law enforcement is incredibly important, and requiring them to hunt for their own funding is difficult. And while there are prohibitions usually on using forfeiture funds for personnel, so that people don't think like their job depends on this, there's still incredible pressures on them. So I would just say, number one, it's very important to adequately fund law enforcement so that they don't need to use civil forfeiture. And so if the carrot can be ordinary budget appropriations as a quid pro quo, to some extent, to grease the wheels here. The stick is victim stories. And in Texas, you've got a lot. Tenaha, Texas is one good example. I'm sure you've got numerous examples of border crossings where oftentimes law enforcement is not interested in northbound drugs, they're interested in the southbound cash. So, hey, go ahead and sell. We're not going to we don't care about these sorts of things, or it's hard and we're not going to get, the money out of it, but we'll try to seize the cash going down. That's a bit of a problem as well. So the carrot is ordinary budget appropriations. The stick can be victim stories because they're out there. The classic case is a college grad, he graduates from college in like New Jersey, let's say. His dad gives him cash. He says, he wants to make it as an actor in California. He drives across country and he gets stopped somewhere in, say, Oklahoma or North Texas, and they end up seizing his cash. That happens all the time, and these folks are very easy to find. It should not be difficult for you to find examples of forfeiture abuse in or around your communities. I guess let me just talk then briefly, I've got about a minute left, about federal reform. It will come up next year. Senator Rand Paul, for example, has introduced a bill where he wanted to remove the equitable sharing incentive entirely. There were some members in the House that had bills that went further with some procedural reform. I guess I'll leave it with that. Just point out that, I've got one. Right, so we've got bills on the House side, bills on the Senate side, and it's going to come up this year. Why is that? Because, I can be on a panel here as a representative from a conservative organization with, folks on the left and, libertarian organizations. People understand this. It's a really easy kind of an issue. There's no lobby, unfortunately, or fortunately, there's no lobby in favor of forfeiture reform because no one stands to make any money off of it, but there's a lobby against it. But things are moving. It's in the popular culture now. And again, just to repeat, the New Yorker article is great. It's called Taken. The Washington Post series of articles are an excellent resource, and the John Oliver segment, you can find it on YouTube. Those are all three things that I would encourage you to take a look at to learn a bit more about this issue. Thanks.
Thank you, Andrew. I have to say that's probably the first time John Oliver was cited at one of our policy panels. I'll be sure to send a thank you card on. Moving on with the panel, Matt Miller from the Institute for Justice is the managing attorney of their Texas office, where he fights to secure property rights, economic liberty, freedom of speech, and school choice. Matt represents individuals and small business owners in federal and state courts in Texas and in and around the country. Matt successfully defended the author and publisher of a book about eminent domain abuse after they were sued for defamation by a powerful developer, and successfully litigated against the city of El Paso, Texas, to force the state to repeal a law that prohibited street vendors from operating near brick and mortar restaurants. His litigation also won legislative repeal of a law requiring computer repair technicians to obtain a private investigator's license. Can you only imagine that here in Austin, if we had something where the food trucks were not able to be in your restaurants? I think that'd be almost an untenable business model. But without further ado, Matt Miller from the Institute for Justice, Texas.
Thank you very much, Derek, and thank you all for coming out for this. I think that Andrew did a very nice job laying the groundwork for this issue, and so I just wanted to touch on a few themes that I want you to take away from this policy primer. And those themes are: forfeiture is big, it is a problem, and and there is something that you can do about it. I'm not going to go into the numbers again because Derek told you the numbers. They're large, and they're talking hundreds of millions of dollars. Forfeiture is big in Texas, it's big around the country, and I don't think I need to convince you all any more of that. But let's talk about why forfeiture is a problem. It's a problem both for property owners and for, I think, law enforcement officers. This is something that Andrew touched on. But let's talk first about property owners. You've all heard the horror stories, and they're real. What happened to the Decos with their business and the structuring case. What happened in Tenaha. There are true kind of shocking horror stories about forfeiture from in Texas and all around the country. But as important as the horror stories are, the everyday machinations of forfeiture are what I wanted to kind of drill down on a little bit. And let me paint a picture for you. Back in 2010, my colleague Scott Bullock and I were in the courtroom in Harris County, Texas. And in Harris County, one poor judge is assigned the forfeiture docket for some period of time. So that judge, a couple days a week, gets to hear nothing but forfeiture cases. And in this courtroom, the prosecutor is camped out and has a quasi-law office on one side of the courtroom. So there are just boxes of forfeiture cases. And the prosecutor and her assistants are camped out there, and they'll be bringing case after case after case in front of the judge as he or she hears the forfeiture docket. There's no one on the other side of the courtroom representing property owners. And when you hear these cases being called, these are not drug kingpins. These are State of Texas versus $823. State of Texas versus one 1989 Ford or Dodge Caravan. In Minnesota, I don't have the number for Texas, but in Minnesota, the average civil forfeiture was $1,200. So yes, civil forfeiture is a useful tool for fighting drug kingpins and major criminals. But more and more, it's used to take small amounts of property from ordinary Texans. And the reason there was no one on the other side of the courtroom is it's not worth it to go to court to try to get that property back. You're not going to pay an attorney $3,000 to get $1,200 worth of property back. So in many cases, I don't know if anyone's gotten a speeding ticket lately, but you'll notice that police will often ask you if you have any cash on you when they pull you over. The reason is that they're looking to seize and forfeit that money. Obviously, speeding has nothing to do with cash, but you're required to answer the question truthfully if you answer it. And they will oftentimes take that cash and then seize it. That's why you get State of Texas versus $832, is these are small amounts of money. And so the judge will call the case, the prosecutor will stand up to represent the state, and then the judge will ask, is the property owner here? And time after time, no, the property owner is not there. Is his attorney here? No, his attorney is not there. And so the judge enters a default judgment against the property owner. And you can see this in Harris County, you can go down and see it for yourself. I'm sure it's the same in courtrooms around the state. It's a petty problem, but it affects lots and lots of Texas property owners. And $1,000, an old Dodge Caravan, those are real assets and real property for these people. And it materially affects their lives when they're taken. They need these vehicles to drive their children to school. They need this money to buy groceries. And forfeiture gives police an incentive to take it without charging anyone with a crime. And that's an important point. We can reform criminal asset forfeiture while still leaving, we can reform civil asset forfeiture while still leaving criminal asset forfeiture as an available tool for law enforcement. If you bring charges and convict someone of a crime, you can take the fruits of that crime. Criminal forfeiture will still exist, but under civil forfeiture, you can take the property, never charge someone with a crime, and the burden is then on the owner to get that property back. So let's talk about why this might be a burden for law enforcement. Whenever we tell people about civil forfeiture and we try to explain it to people, one way in which people would push back is they would say, well, that's not actually going to skew law enforcement priorities because police are good people. And police are good people. And this isn't about police or prosecutors being bad people. But it's about incentives that incentivize good people to prioritize certain things, like civil forfeiture, instead of other things, like other law enforcement activities. So we worked with some professors who conducted a study. And it's an area called experimental economics. And it's actually a Nobel Prize winning area of economics, but it's hard to explain to people. It involves a series of games that people play, and you test different incentive structures within those games. And so we wanted to see, do incentives affect the behavior of ordinary people? And the answer is yes. The kinds of forfeiture incentives we have in Texas and around the country absolutely influence people's behaviors. And here's what the authors concluded. They said, the experiment's results suggest that the problem with civil forfeiture is not one of bad apples, but bad laws that encourage bad behavior. It is not the players, it is the game. When civil forfeiture puts people in a position to choose between benefiting themselves or the overall public, people choose themselves. And, you know, if we reform civil forfeiture, we could allow police to put their efforts and to put their activities into pursuing law enforcement goals that we can all agree on, rather than pursuing civil forfeiture. And I imagine the burden on them would be much less. Because again, these aren't bad people. But if they have to fund 30% of their budget through civil forfeiture, they're going to pursue more civil forfeiture. And that takes time and police energy away from other activities that can be better spent protecting the public. So I hope you're convinced now that forfeiture is a problem. It's a problem for property owners, and I think it's a problem for police and prosecutors. Let's talk about what we can do here in Texas to address the problem. I've already said you could eliminate civil forfeiture. North Carolina doesn't have civil forfeiture, and yet police and prosecutors are able to operate there without problem. Minnesota just passed a law requiring a conviction for forfeiture. Now, it's still technically civil forfeiture, but someone has to be convicted of a crime. So you essentially eliminated civil forfeiture in Minnesota. Texas could do the same thing, but short of that, there are 4 things. You could eliminate policing for profit. Require police and prosecutors to take that money and put it into some kind of general fund, where you then have a legislator or a city council or county commissioners who are deciding how that money gets allocated. They're not self-funding anymore. The money goes into the general fund, and then the individual elected representatives decide how that money is going to be spent. Second, you could provide greater protection for innocent owners. And in the forfeiture context, innocent owner is a technical term. I would argue that a lot of the people who get their money or cars taken and aren't charged with a crime are innocent. In fact, if they're not charged with a crime, I think we can presume they're innocent. But something else happens where someone loans their car to their son, and their son is out dealing drugs out of the car. And then the police bust the son for dealing drugs. The son is actually convicted, but the police and prosecutors take the car, and then it is the owner's burden to prove that they didn't know that the car was being used in conjunction with illegal activity. That's backwards. It should be the government's burden to show that the owner knew or should have known that the car was being used in conjunction with illegal activity. It's very hard to prove a negative, and it's also expensive. And these innocent owners who have their cars taken or have their houses taken have to pay for their own lawyers. And then they have the burden of showing that they're innocent. That's a due process problem, and we can address it by shifting the burden through a change in the law. Third, I think we need better reporting. We have reporting in Texas, and it's C+, B-. As far as a high-level overview, I think it gives you big numbers. That's the numbers that Derek was quoting. But what we don't know, and what we should know, is how forfeiture is actually being used on the ground. Forfeiture is an awesome power. It's the power to take someone's property and make them get it back. If we're going to allow police and prosecutors to use this power, we need to know how it's being used. So let's know exactly what's being taken. Let's know how many default judgments there are. Let's know whether or not the property owner hired an attorney. Let's know where the money is going and how it's being used. This wouldn't be that hard to report. And like I said, if you're going to give someone this power, they should be accountable for it, and we can make them accountable for it through increased and enhanced reporting. And finally, and Andrew touched on this, there's the problem of equitable sharing. So no matter what Texas does, no matter how much we reform our state laws, local law enforcement can circumvent those laws by teaming up with the federal government, and then they split civil forfeiture money, 80%, 20%. 80% goes to local law enforcement, 20% goes to the federal government. Texas can limit equitable sharing or eliminate equitable sharing, but something I might propose is a floor for equitable sharing. Some U.S. attorneys' offices have this. They won't do equitable sharing cases that are below $25,000, that are below $50,000. So you can still use equitable sharing for the drug kingpins in the big cases, but it eliminates the penny ante stuff, the stuff that I saw back in the courtroom in Harris County, and it allows Texas reforms to actually have some bite. And I think that, as a state that values our independence from the federal government, we should be pursuing that, because if we reform civil forfeiture, which I hope we will, we want those laws to be effective to protect the property owners of this state. I'll take questions once we get to the Q&A period. Thank you.
Thank you, Matt. Shannon Edmonds is the Director of Governmental Relations for the Texas District and County Attorneys Association, or TDCAA, the largest statewide association of prosecutors in the nation. Mr. Edmonds serves as a liaison between prosecutors and the Texas legislature on issues of criminal justice, juvenile justice, and governmental representation issues. Upon conclusion of each session, he authors the